MI5 gathers intelligence, police gather evidence, but those are not the same thing. So how do MI5 and the police work together in the UK, and what can't be shared between them? The answer is more complicated than most people realise, because intelligence can prevent attacks, but evidence must survive court. The first thing to understand is the difference between intelligence and evidence. Intelligence is information. It can come from surveillance, from human sources, from signals, from partners. It may be incomplete, it may be unverified, and it may be too sensitive to reveal. Evidence is different. Evidence must be disclosed. It must be admissible. It must be testable in court, and it must be presented in a way the defence can challenge. This is why intelligence cannot simply be handed to police and treated as proof. The legal system does not work that way. MI5 is not a law enforcement agency. It does not arrest, it does not charge, and it does not prosecute. Its role is national security. It identifies threats, it assesses risk, it disrupts networks. But when a case enters the criminal justice system, police and prosecutors become central. Because the standard changes, the goal is no longer disruption, the goal is conviction, and conviction requires evidence. MI5 and counter-terrorism policing work closely. They share information through formal channels, joint teams, tasking structures, secure briefings, and controlled intelligence products. But sharing is not automatic. Information is assessed for sensitivity, source protection, operational risk, and legal implications. In many cases, MI5 can share the substance of a threat without revealing the source. This allows police to act, execute search warrants, increase surveillance, disrupt travel, or prepare an arrest. But the intelligence itself may never appear in court. Some intelligence cannot be shared fully for one simple reason. It would expose capabilities, or it would expose sources. For example, a human source inside an extremist network, a sensitive interception method, or intelligence from a foreign partner with strict conditions. Sometimes the police may know that MI5 has high-confidence information, but they may not be told exactly how it was obtained. This creates a challenge because police still need evidence, so they must rebuild the case in a different way. Using surveillance, digital forensics, witness statements, financial trails, and legally obtainable material. This is one of the most important realities of counter-terror work. The strongest intelligence is often the least usable in court. This is where the system becomes procedural. MI5 identifies a threat. Police begin evidence gathering, and the CPS assesses charging thresholds. If a prosecution is likely, the case moves forward. If not, disruption may be used instead. This is why some arrests lead to terrorism charges, some lead to non-terrorism offences, and some lead to release without charge. It doesn't always reflect the seriousness of the threat. It reflects the legal strength of the evidence. The courts require disclosure, and disclosure can create national security risk. So the system must constantly balance public safety, justice, and secrecy. So MI5 and police do work together, but they operate under different rules. MI5 focuses on intelligence, police focus on evidence, and the gap between those two worlds is where many counter-terror cases are won or lost. Sometimes the system produces a conviction, sometimes it produces disruption, and sometimes it produces nothing visible at all. But the logic remains consistent. Protect the public, protect sources, and act when the legal threshold is reached. In the next video, we'll break down the UK Disruption Toolkit, the methods used to stop a threat even when prosecution isn't possible.